Today, we're going to talk about changes in planning law in Belgium and the Netherlands. There are a lot of legal changes and also questions whether you can change the culture of planning through law and what kind of opportunities do law changes have. And we will have presentations from Rene Van Der Leck, Kristel Jeuring, Rogier, Kegge, and as a discussant, we have Danielle Chevalier. And as I said, this session is recorded and we put the audience on mute, but we ask the audience to make use of the chat and the Q&A button, and please post all your questions there. After the presentations of the presenters, there is a lot of opportunity to raise your questions or your concerns or make statements, and we will make sure that your voice is being heard. So without further ado, I want to introduce the first speaker, Rene Van Der Leck. He's working for the Flemish government on policy innovation, and he's he works for the Beleidsplan Ruimte Vlaanderen, which is loosely translated to Spatial Policy Plan Flanders. Rene is an expert on European and cross-border spatial projects and has also worked for the European Observation Network for Territorial Development and Cohesion, ASPON. And he will give a presentation built on his expertise. And I will stop sharing so Rene can take over.
Yeah, thanks a lot, Michiel, and also a good afternoon on my behalf. When the wind blows in Flanders, it often blows from the north, and this means that this whole conception of omgeving also is coming with the wind to Flanders. This is a bit of a fuzzy word, combining something like spatial planning and environmental law and policy. And we are quite puzzled. Of course, we are also working with this concept of omgeving, but yeah, is there any common ground in these two policy fields when we make laws and policies? And what I'm going to tell you today is yeah, some observations and some first foundings in some policy exploration work that we are currently doing in our department. I first want to give you a quote. One of the management board members of our department once said when I was in a meeting with them, when you know you have to do something like the Dutch, but you feel that their approach is not the right one. I think this all summarizes things very well. We are looking at, of course, very closely at what is happening in terms of omgeving, this combined thing of planning and environmental policy. But we also look at what is happening. It takes a lot of time. It seems very big. It seems very difficult. And at the same time, we are working with this concept as well. So maybe we should dive a little bit into what this concept is or is not. It is, I think, a very fuzzy concept. Interesting is that omgeving is a Dutch word without any translation in other languages, which makes it a very weird kind of thing. But it is something like a combination of the living environment and yeah, what we call the spatial or territorial state. Of course, this gets some historical background. I think in the 70s of the last century, we saw a growing concern about the environment. Limits to Growth was being published by the Club of Rome. And as from the 80s onwards, environmental policies were being set up in also in Belgium in national and regional policies. The awareness slightly on was growing of this relationship between environmental and spatial policy. Already in the early 90s, we had what was called a ROM project in the canal zone of Ghent. And ROM basically means spatial ordening, ruimtelijke ordening, and environment, milieu. Where practitioners were already trying to combine these two elements of policy making. And also, of course, in the second half of the 1990s, in the spatial structure plan for Flanders, some of these environmental concerns were interwoven into spatial policy making, in particular with concepts like sustainable spatial development, the carrying capacity of space. But what we are seeing is that this environmental interference in planning procedures was growing and growing. Environmental impact assessments for spatial plans were to be made. We have this permanent friction of environmental permits versus planning permits. Once planning permits were delivered, sometimes it didn't mean that from environmental concerns, this building and construction could find place. So something of the historical concerns. This led to quite some legislative work also in Flanders, very much being inspired from what was happening in the Netherlands. And in 2014, we saw that at least this we also introduced the integrated permit for space and environmental concerns. So one application which combines at least the spatial, the considerations and the environmental considerations. So a yes means a yes and a no means a no. And we also had this degree on complex projects, what also was addressing for more complex projects, integrated planning approach, taking on board all environmental concerns. Then in 2014, later on, there was this establishment of an integrated policy domain. We had in 2016 the integrated environmental impact assessment into the planning, into the plan making. In particular, first the destination plans, later on also the other local spatial plans, more strategic planning. And in 2017, this policy domain omgeving, combining spatial development and environment, was being completed with the establishment of a department for omgeving, spatial development and the environment. And this all left us with the question, what's next? We felt, even though, we did quite some progress in terms of institutional and procedural integration, we still are living with this feeling of what binds really these two policy domains together. What is the content of it? And we started to have to look into what was happening in other places around the world. Other governments also doing efforts in order to integrate spatial and environmental law and policy. We looked at, of course, what is happening in the Netherlands, but also we looked at the example of the Basque region, South Africa, the Brussels region, and Ireland. And we defined different types of reasons for integrating spatial and environmental policy and law. Particularly, we see governments are doing so in order to create more coherence in public action, to deliver faster, to have faster project delivery, And also this integration is used in order to better use a co-creative civil society. In particularly, we were quite impressed of the Irish example. I'm sorry for the Dutch audience here, but we were impressed by the colleagues in Ireland, in particularly of what they were doing in terms of coherence on the content side. It was the moment that Ireland was completely financially bankrupt in the financial crisis, when there was a force there in order to create one combined planning framework for Ireland that takes into account and provides a basis for all European legislation and for all European funding. So in order to have all these kinds of different fundings coming from Europe, they wanted to use it as effectively as possible, which was necessary in the aftermath of the crisis in Ireland. And I think in terms of having this vision, really providing a basis for using all kinds of European funding and having this integrated development approach amongst the different policy sectors, I think this is quite some impressive work. So this is what we are a little bit jealous at. But still, in Flanders, we are not there yet. I take here two quotes in some degrees. A degree, by the way, this is a regional law in Belgium. So I take two quotes out of two laws, a Flemish degree and the Dutch Omgevingswet. And what you here see is when they provide a description of what omgeving is, you see some kind of summing up. It is a series of themes, policy domains, and that altogether is omgeving. But does this give you a real idea of what omgeving is? Is it more than just a summing up? So what we see, what we try to understand is what is the object for policy and regulation actually? Is omgeving more than just a sum of thematic issues? And can we also work on, let's say, a more substantive integration? Because as we've seen up to now, legislative initiatives were much more mostly pushed forwards in order to create some kind of efficiency and simplification. But we have no clear answer, I believe, especially in Flanders, at what omgeving policy should really steer and law should steer. What are we really monitoring? Do we have some kind of conceptual framework? And what we still see very often is that there are single themes solutions, as I call them, being proposed, causing on the same hand problems elsewhere within the main policy domain of omgeving. And then the question is this really integration? I just give a few examples that we know in Flanders, but maybe they are very recognizable also in the Dutch context. Densification versus urban heat. How should we look at these issues? The nitrogen disposition versus our wish for urban development. Sustainable energy versus nature conservations. I put a picture here of solar screens on a water lake with natural importance here as an example, but also the construction of cycle paths versus this idea of soil sealing and CO2 capturing. So many of these solutions or many of these issues are not being given an answer by this concept of omgeving, whereas I believe that omgeving should do so. So we have been working on what omgeving as an object for policy and regulation actually could mean, and we come up at this moment with this definition. Omgeving is the omgeving, the physical living environment, is a system of layered supplies or stocks and abiotic flows between them. This is very important. These supply and these stocks, they are at the core of this definition. And we see that spatial policy only address often the layer of the surface level. This is then being instrumentalized in all kinds of maps, master plans, destination plans. And of course, this layer contains important stocks like the available open space, the space for forests, or important residential area. But omgeving really puts this layer into its three-dimensional context of the physical living environment and demonstrates all kinds of interrelationships between territorial planning and, let's say, the functioning of soil, the functioning of the underground or water systems. And then, hence, policy and law for omgeving aims at the state and or the quality of the physical living environment and the organization and development of human activity as far as they impact the physical living environment. So this is some direction in which we try to have more clarity on what omgeving could mean. And of course, this is also important when we start to think about the development or the creation of new legislation, which is at this moment what we try to explore. What we currently think of is that we have to integrate the two basic degrees for the environment and for spatial planning into a framework degree omgeving. We think it is too much to integrate all thematic themes, but in this framework degree, we have to, we want to describe these common notions. We want to provide a common vocabulary and some basic concepts on how to address and how to understand omgeving, and also provide common core principles and aims that can be further developed in, let's say, thematic plug-in degrees that takes a partial object within this physical living environment, or that addresses one type of human activity that is, of course, subject to some kinds of norms and regulations. So this is where we stand. Still, in my head, it's quite fuzzy. But we try to understand what omgeving is, and maybe in my presentation you also noticed some kind of criticism on the Dutch approach, but maybe if we keep on talking, maybe we will find out one day together what we are actually doing. So thanks a lot, and Michiel, I give the floor back to you.
Thank you for this very stimulating presentation. And indeed, we heard some criticisms of the Dutch system, which are always welcome, of course. We will continue with the next presentation. And the next presentation is by Kristel Jeuring. She's an expert in community rights, citizen-led policies and community building. She works for the Landelijke Samenwerkingsverband Actieve Bewoners, which is an interest group for citizens who actively aim to improve their neighborhood. Through her work, she has a lot of knowledge and experience about the barriers and windows of opportunity that citizens face when they set up community-led projects. And I give the floor to Kristel.
Thank you, Michiel, for giving me the opportunity to talk about this topic. I'll share a few slides as well, if you bear with me a second. Let me get that set up. Is it? Of course, we just tried this. Let me make this. Yeah, there it is. Sorry for that. So yeah, again, thank you for this opportunity. I think I have to put in a disclaimer. And the disclaimer is I'm not a planner. I'm not a legal expert. I'm not a policy maker. So some of the conversations might be going over my head a little bit, but luckily I do have a particular perspective that I think might be of interest, or at least I hope it's of interest, especially because I think for the group that I'm talking about, having access to sort of planners is really important. So I hope also that within this room of participants, I find a few people who perhaps think that this is a good opportunity to get in touch with their local communities or the communities they might be interested in working with. So hopefully I'll be doing a bit of my missionary work in that regard as well. So there's a lot of things I am not, but I do work for LSA. And perhaps to give a bit of color to what that means, we work with community groups all over the country. We're a membership-based organization, and we do a lot of knowledge sharing, and sometimes we might do lobby work towards national government as well. And the omgevingswet has been one of those topics that we've been trying to do a little bit on. And that's because actually community groups do quite a lot in this domain. If, for example, I've taken a few examples from Rotterdam, the Schepenstraat. People who live there decided that actually when their street needed to be redesigned, they figured that maybe that's something they could do for themselves. And they did so quite successfully, at least from their perspective, which is relevant, I guess. In Bospolder Tussendijken, a community group are working on developing an energy transition plan. The Wijkpaleis is taken on a big community asset. So there's all these things that happen in sort of public space, but that are about more than just that public space, I guess. So there's definitely a big interest from our members to get involved in sort of developing new practices and new culture. And I guess that is actually quite necessary. So perhaps a bit of on my background, I worked for LSA, but before this I worked in England for a similar organization. And I worked there from 2013 to 2016. There was a lot of excitement at the time, and I think there still is, about the neighborhood planning framework. So when I came back in 2017, that was the kind of excitement that I was sort of coming back with. Because I think in terms of sort of interventions in community sphere, that has been hugely successful. So the uptake and the interest for people to really come together and figure out what their neighborhood should look like, from the very complex to the very simple, was quite astonishing. So when I started having conversations with our members about the omgevingswet, that was sort of the excitement that I came back with. And there were quite a few people who sort of shared the excitement about omgevingswet as well, because just looking in general about the types of issues that communities might face, it revolves a lot around the silos that bureaucratic systems work in. So the things they would see in their neighborhoods would never neatly fit into one of those silos that might engage with government in. And the omgevingswet that I guess promised to look for a sort of closer integration amongst different domains. So even if you were talking about, for example, planning and what public spaces might look like, you could also have a conversation about health and well-being, and maybe what you need to do to create a sense of community within a neighborhood, or safety. And you could start to wrap all these things up together, which is really quite exciting for communities, in part because it was directly relevant to the projects they were doing, but also how maybe this particular new framework of the omgevingswet could maybe change the culture and practices in other domains as well. So other kinds of conversations they would be having with their local authorities. So there was quite a bit of optimism there. And in addition to that, there was also sort of the idea that maybe there would be more space for communities to take initiative. So it would be easier to take initiative. And perhaps their role as an actor within this whole domain could increase through these means as well. but unfortunately, and the longer, I mean, this was 2017, the longer we talked to people, there were quite a few concerns as well. And those concerns were actually rooted in sort of current culture and practices. And I think one of the main things that, at least in the Netherlands, what I've noticed is we don't like to talk about power. We might talk about influence, but power seems to be some kind of dirty word. And communities sometimes struggle with expressing actually that they would like more power as well. And I think it's relevant because if you look at sort of the playing field, what you see currently is that it's basically the government and the market playing the game, and civil society gets to sort of be there as an audience and sort of sit on the benches. And you see that in different ways. So for example, if you talk about informal power, it's sort of the access to means, but also the access to sort of knowledge and power and information. So obviously these are very complex topics. And when community groups might think that they have figured out how one process works, there will always be someone who says that actually that is not the game that we're playing here. There's a different game, so you need to learn a new set of rules. Or yes, that was the game that we're playing, but we've just added a different rule, or at least that's how people might experience it. And similarly, because they're sitting in the stands, they don't necessarily have access to sort of the gatekeepers, the decision makers. So that's a struggle in terms of actually making a change in their neighborhoods. And similarly, formally, there are not that many things that communities can do. So we have a fairly rich tradition of involving communities in decision making when it comes to, for example, public space. But when you look at what happens in practice, that's often about allowing people to give their opinion about proposed ideas. There are some exceptions. There might have been a referendum about a very specific proposal that a government has put forward, and you can say yes or no, or maybe A or B. And there's some progressive local authorities that really take this role very seriously. And I remember a process in Hengelo where a new market space was going to be designed, and that was a very proactive sort of co-creation process. But you are dependent on whatever civil servant you might find in that local authority and sort of the context. So these were sort of the concerns that people were already sort of struggling with. And then the question is, of course, can the omgevingswet actually change those things? And where people were previously optimistic about that, people are now actually thinking maybe that optimism wasn't entirely warranted. I think, first of all, if you look at sort of participation, I'm not entirely sure. I mean, I haven't read the entire text, and I have to admit I probably never will read the entire text. That's not my sort of my skill. But I think the word participation was maybe included 3 times, something that sort of that scale. And when it is mentioned, it says something along the lines of whoever proposes a new development has to involve stakeholders at an early age. And there's a real lack of sort of specificity and definitions there. So what does it mean to involve? And who are stakeholders? And what does it mean at an early stage? So there are no very sort of the playbook is not very specific. And if you look at the previous picture, you saw that you sort of had government and sort of market across from each other. And the idea was maybe that it would become something like this, a sort of a level playing field. But because the responsibility for participation is now put on the party who takes the initiative, works on the development, it is even a question whether the government could still really be the protector of the quality of the participation process. So even though when I was talking to optimistic people, we were looking at sort of that left picture of where we get an equal playing field, whereas in practice we might be getting the picture on the right. A market party who's proposing a development and has maybe put a very small ad out in a newspaper in sort of font size 7, announcing that there will be a development, and there's this one evening in the middle of the winter starting at 10 in the evening where you can listen to the plans that they're proposing. So that's I think a real concern. However, it doesn't have to end up like this. So I like to think that when I try, I can be a real optimist. So there are definitely ways to turn this around, and we have quite, I think, some interesting experiences, especially within the Dutch context, but perhaps also in different countries on how you can do this. So what is nice about the neighborhood planning framework in England, which got me so excited, is that it's specific. You know, you have a real formal right to do things. I'm not sure if we're ever going to get to that point in the Netherlands, but there are other options that we have, and this is, you know, there's definitely a lot more that you could think of. But when I was talking about before, we could really create a specific participation playbook with very clear definition. So who are stakeholders? What does it mean to involve people, and at what stage? And make sure that this playbook and these processes are a requirement for everyone. So not just when the government takes initiative, but actually also when market parties do this. Could we maybe give communities access to knowledge? Are there people they could consult with? Are there maybe funds that they could access to buy in this kind of support? How do we define sort of transparency? Do we have to take out that, is that little ad in the local newspaper sufficient, or should people put on a big sign in any kind of location that they might have any plans to develop? Do you want to maybe use a tool such as the right to challenge or the right to bid? That example of the Schepenstraat, people use the right to challenge to actually say, this is a part that you normally do, local authority, but why don't you let us do that and give us a budget that you would normally spend on developing these plans? Make use of community cost benefit sharing agreements. So when a new development takes place, you look at, does it have positive impact on the neighborhood, but it might also have a negative impact on the neighborhood, and how do you share those sort of costs and benefits? So there are all these kind of things that we can build in if this is something that we think is important, and I think we have to find a way to sort of to balance what do you put in legislation and what do you make part of sort of local practices. So that would be my missionary, I guess, statement for this afternoon.
Great, thank you so much. That was very interesting, and it's actually very great that you don't have the perspective of the planner or the lawyer or the academic, because, well, it's all about the society. So it's great to have your perspective. We will continue with the final speaker, and the final speaker is Rogier Kegge. He is Assistant Professor Administrative and Environmental Law at Leiden University. He used to work for the Dutch Council of State, Raad van State, and wrote his PhD dissertation on intergovernmental supervision of spatial planning in the Netherlands, if I translated it correctly. In 2017, yes, great. It's always a little bit awkward with translating Dutch legal terms to English. In 2017, he wrote with Frank Groothuizen the yearly advice of the Association of Construction Law on the Environment and Planning Act. And I will give the floor to Rogier.
Yeah, thank you. I'm going to share my screen. Well, I'm a lawyer, so I'm going to make it a bit more legal, I'm afraid. So bear with me. I'm going to talk about a popular instrument in Dutch planning law in the recent 10 years, and that's the programmatic approach. And well, one of my main questions with the programmatic approach is it can you use it as a policy instrument, or should you use it as a legal framework? And if you choose to use it as a legal framework, what are the conditions to let it function? Because we've had some, well, let's say accidents with programmatic approaches, a big accident with the programmatic approach nitrogen. And my research is, I'm looking into the question, why did this rather awful accident with our programmatic approach happen? And was it to be expected? Well, I can already say it was to be expected, but so this is, without further ado, the programmatic approach. This is my short index. I will look into the origins of the programmatic approach. I will I will look into the key elements of the programmatic approach, and then I will show two examples, one successful and one not so successful. And then I will come to the question, can you use it as a policy instrument? Can you use it as a legal framework? And what are the risks? Well, if you, why is the programmatic approach still so popular? The last 10 years, you hear a lot of lawyers in the field of environmental law. They are advocating programmatic approaches. They want to see more programmatic approaches. And why is it so popular? Well, because if you look at the origins of the programmatic approach, which is adaptive management, it promises robust decision-making within the face of scientific uncertainty. Well, sound good. So, and it offers more flexibility if you want to integrate decision-making within an ecosystem approach. So you take decisions and you say, okay, but we're going to monitor the effects of those decisions. And if those effects are worse than expected, we can adjust the system within itself. So it's more flexible than changing the law every time if something goes wrong. So this meant, if you look at this system, it was immediately quite popular among environmental lawyers because it promises flexibility. But there are some problems with converting adaptive management into law, because you have to look at special requirements based on legal requirements, because you have to look into legal certainty. Do you want to make the decisions open for appeal? What are you going to do when monitoring shows that the effects are worse and the permits are already irrevocable? So these, the question if you want to use a programmatic approach as a policy instrument or as a legal framework is quite an important question. If you look at our programmatic approaches until so far, those systems are systems of passive adaptive management, because if you look at the origins of adaptive management, you have two forms. One of the forms is active adaptive management, which is a system with a deliberate experimentation. Well, and the programmatic approaches in the Netherlands did not include active experimentation, but were systems which were legal frameworks or policy instruments which had a system of monitoring and adjustment, but not deliberate experimentation. Well, this means in the Netherlands, the programmatic approach has been popular, but we've learned a lot with our two main programmatic approaches we've had. And if you look at those programmatic approaches, you see certain elements recurring in every programmatic approach. You have to have a set of objectives, one or several, and they have to be achievable, and quite important, they have to be verifiable. You have to have a set of measures. And if you implement a programmatic approach, you also have to have the obligation to carry out those measures within a certain time span. And quite important, if you look at the third key element, if you want to use a programmatic approach with a so-called room for development, or in Dutch, milieugebruiksruimte, you also need a method of allocation of those rights. And this is quite important. And well, the most important thing in a programmatic approach is you need a system of monitoring and a system of adjustment, because you want to monitor the effects of the programmatic approach itself. So you need a reference situation, and you need to limit the temporal and territorial scale of your programmatic approach, or else you won't know what you're monitoring. And of course, if you use monitoring, you need a system of adjustment if the monitoring shows that there are the effects of your program are worse than expected. So these are the key elements of every programmatic approach. In the Netherlands, we've had 2 programmatic approaches until so far, one quite successful and one rather disastrous. The first one is the successful one, and that is the National Air Quality Cooperation Program, in Dutch called het Nationale Samenwerkingsprogramma Luchtkwaliteit. And it was directly based on the air quality directive, because the directive provides if there is a risk of exceeding limit values, you have to make a program. And this is such a program, because in about 10 years ago, we had quite severe problems with limit values in the Netherlands. And this was the program which was aimed at reducing emissions and improving the air quality. But it's like the Dutch always want, it's also called in Europe the Dutch approach, because we never do something for free. We always have twofold objectives. We want to improve air quality, but we also want to add new economic activities. And the same you see with the programmatic approach to nitrogen. And I think it's really quite funny that in Europe they call it the Dutch approach. Well, this is the objective. Then you have a set of measures, and it was a quite elaborate program of measures. And eventually it was aimed at complying with the air quality directive. And it has been quite successful. In the most of the areas where there were problems with limit values, they have been solved. There are some problems left in big cities and in areas with a lot of livestock farms, but the general picture is that Netherlands now complies with the air quality directive. So this worked. It was based on the air quality directive itself, and it's mainly a policy instrument. But then in 2015, the programmatic approach to nitrogen came into force. It was meant to implement the Article 6 of the Habitats Directive. And in the Netherlands, we had a lot of problems with nitrogen and far too high deposition on our special protection areas. And we've had that problem for many years. And then the programmatic approach to nitrogen was introduced. Here you see also the twofold objective, and it is, of course, it was aimed at a decline of the nitrogen deposition, but it was also very much aimed at facilitating new economic activities and quite important, at deregulation, because a lot of those activities were also, you didn't need a permit for it anymore, as long as your activities were in line with the programmatic approach nitrogen. It also had a set of measures, source measures, restoration measures. It had the legal obligation to carry out those measures, and it had an elaborate system of monitoring and adjustment. And eventually it had to lead to the favorable conservation status of the special protection areas in the Netherlands. Well, this did not happen. And the Council of State had some doubts on this program, if it was in line with the Article 6 of the Habitats Directive. And they asked preliminary questions to the European Court of Justice, and the Court of Justice said in 2018, well, you are allowed to work with a programmatic approach like this program, but you cannot use this program, because if you look at Article 6 of the Habitatsrichtlijn, it is an implementation of the precautionary principle, a quite an important principle in environmental law. And if you look at the precautionary principle, it focuses on reducing risk before you take a decision. And the precautionary principle focuses on reducing scientific uncertainty before you take decisions, while a programmatic approach focuses on monitoring effects after you take decisions. And this is the big problem with the programmatic approach to nitrogen. It is a programmatic approach with a focus on monitoring ex post, but it's also an implementation of the precautionary principle, and that's an inherent. It has an inherent tension in it. Well, this leads me to this slide. If you look at programmatic approaches and you want to use it as a policy instrument, or you want to use it as a legal framework, those are two different things. If you just want to use it as a policy instrument, it is more flexible. You can easily change it. There are no procedural requirements and no administrative appeal, and you can deviate from a policy instrument. But if you implement a programmatic approach as a legal framework, you have to make sure that there's legal certainty when you issue out environmental rights. You have to make sure the measures are enforceable, and you have to make sure that there is administrative appeal. Of course, it's possible, but those are things you have to realize. Well, if you look at the precautionary principle, like I said, if you implement the precautionary principle in a legal framework, inherent thing of the precautionary principle is always the assessment of the uncertainties before you take decisions. So if your system is based on the precautionary principle, monitoring is only a little extra, but it cannot be the main thing in your system as such. And this is the big problem with the programmatic approach to nitrogen. Not only in the Netherlands, because in Flanders, there's also a programmatic approach now, and Belgium court has already said that their threshold for significance is also not in line with Article 6 of the Habitats Directive. And here you see that programmatic approaches combined with systems based on the precautionary principle are fundamentally problematic. Well, is this the end of the programmatic approach? The Dutch programmatic approach to nitrogen was annulled. The NSL is successful, but will end in 2023 probably. But in our new Environmental and Planning Act, and there are, I heard today, they're not only fans, there is a programmatic approach implemented in the law, but it is fundamentally different from the programmatic approaches we had until so far. Because if you look at the regulation in our new act, it is mainly meant as a policy instrument, and there's a small possibility to use it as a legal framework. That is the yellow part of my slide. Then you can use it as a legal framework, but it is quite good to see that in our new act, it is used for really smaller territorial and temporal scale problems. So national programmatic approaches are, I think, part of the history now, because they tend to be too difficult, too complex, and too uncertain. Well, this is what I had to say about the programmatic approach, and I'll stop sharing my screen now.
Thank you, Rogier. That was very enlightening and really great to have the real legal perspective on the Omgevingswet. And already have a lot of questions, but I'm not the first one who can raise questions, because that is Danielle Chevalier. It's our discussant of today, and also, by the way, member of our Law and Policy team from UGoveRN. She's also assistant professor Law and Society at the Van Vollenhoven Institute at Leiden University. And she has an interdisciplinary background because she has degrees in anthropology, sociology, and law. And she defended her PhD dissertation titled Playing It by the Rules, cum laude. Her research focuses on the interplay between the legal and the social in the urban setting. And I will give the floor to Danielle.
Wow, that was really a nice introduction. Are you for hire, Michiel? Like
Of course, always. If you have a bad day.
Hi, everyone. Thank you, and thank you for giving the floor to me. I would like to begin with remarking what a wonderful combination of speakers and expertise have come to the table today. So the UGoveRN network, which is hosting us today, is about rethinking urban governance, and the organizing chapter is Law and Policy. But I think we'll all agree that urban governance, of course, takes place at the crossroads of law, policy, and community. And we had all three domains represented really marvelously today. So the community tier was specifically represented by LSA. I looked at the website and browsed through it for a bit. And I found a quote from the director. And I'm going to quote it in Dutch, but I will expand on it in English. But in Dutch, the quote is: Beleid werkt pas als de direct betrokkenen zoveel mogelijk zelf regie houden over wat belangrijk is voor hunzelf en hun omgeving. Now, to be honest, I spent quite some time trying to translate this verbally and failed. But I think the key argument being made here is that policy doesn't work without community. And what I like in the Dutch wording is that the community should keep, not be given, but keep. Regie is the Dutch word. And it translates into control, but that isn't really the same connotation, right? Because regie in Dutch, for me, has a very strong connotation to governance. And so the message I hear in this quote is that urban governance should be kept, not given, but kept with the community. Now, elsewhere, I found a statement, whatever the problem, community is the answer. And I like that one as well. But the big message is policy will not work without community. Now, Kristel Jeuring, who is today representing LSA, focuses specifically on community rights. And that brings to mind, on the one hand, the right of the community, the right to the urbs, the right to the city, for anyone into Lefebvre, but also the Latin adage that ubi societas ibi jus, which means where there is society, there is law. Right? So we have this interplay between policy, community, and law. Policy doesn't work without community, and where there's community, there is law. And I think this interplay has been nicely highlighted today. I also think, as a side note, it's interesting to note the wide range of disciplines represented today, because if I'm correct, Rene holds a master in spatial planning. Kristel holds a master in political communication, advocacy, and campaigning. Rogier holds a PhD in administrative law, and I have the legal background, but a PhD in sociology, as Michiel just marvelously noted. But my response today is informed by my grounding in this social legal domain, and looking at the key questions that were put as a lead for today. Can planning acts, and I'm reading this off screen now, but can planning acts, such as being introduced in the Netherlands and Belgium, change the practices and the culture of planning actors? And can a law change, a change in law, institutionalize a new governance culture? So the central question put today is, can law bring about social change? Can it bring about change in practices, change in culture, change in governance? And that happens also to be one of the main questions in my own discipline, the social legal studies. But the question, can law bring about social change, is actually not one question. It is a compilation of several questions. What is law? What constitutes change? And what triggers what? Does law trigger change? or does change trigger law? Now, this first question, what is law? It's a lot more complicated than a non-lawyer might think. And it's part of considerable debate also beyond the legal domain. And I think it's a central question within urban governance, right? And it was a part of the session, the webinar that preceded the session today. I think also if you look on the urban UGoveRN platform, you'll find this really marvelous blog written by Tobias Arnoldersen on the distinction between law and policy. I think in the session following up on this one of the people coming in is Pauline Westerman, who will, I think, argue that the divide between law and policy is blurring, especially when talking about EU law. So this question, what is law, what is policy, what is law? It's a really big question. It's also just one of the sub-questions of the question posed today. Can law bring about social change? So change, what compromises change? What constitutes change? If you want to define change, it means you also have to define the status quo. What is the entity up for change? So translated to today, and our topic and our question set of today, what are the current practices and the current culture of planning actors? What precisely is this current governance culture? And the third one is the chicken and the egg question. Is it law bringing about social change, or is it social change bringing about law, new law? Ubi societas, ibi jus, we said. Where there's society, there's law. But what precisely constitutes what? Does law structure the social, or does the social structure law? Is law an independent variable, or is law a dependent variable? So the idea that law can be an instrument of change considers law as an independent variable. But is it? Is law an independent variable, or is law a social institution that changes as society changes? Or in other words, a dependent variable. More concretely, there are some who argue that the Omgevingswet, the new planning law, might be new as law, but actually as it doesn't entail much more than codifying and solidifying changes that are already taking place and that have already taken place. So this question today of the webinar, can law bring about social change? I'd like to flip it. And I'd like to ask all panelists, could it be that law is following social change? And that the coming about of the Omgevingswet in the Netherlands, or the not coming about, I think the verdict is still out on that one, right? The not coming out of, because that's also an event, actually only really reflects changes that have already taken place and that are taking place right now. Thank you.
Thank you, Danielle, for these great comments and questions. Really interesting. And I already see that all the speakers have unmuted themselves. I will start with Kristel. Can you respond? Yeah.
Yeah, thank you, Michiel, but also thank you, Danielle, and for pointing out the consistency in our argument that basically, well, whatever question you ask us, the answer will be community. So I guess that might be sufficient for my contribution. But I think, I mean, obviously, I don't know it in technical terms, but I think maybe an example of where you see sort of an iterative process. I think I mentioned right to challenge before in my as a way to maybe as an instrument that can be used within sort of the bigger framework of the Omgevingswet. And I think what you saw there was that sort of society was changing in the sense that community groups were doing all kinds of things that were really within the domain of local authorities. And they said, actually, it makes sense maybe that the budgets that local authorities have for this, we get access to that to keep doing this and maybe doing it better, doing it more efficient. But even though there were examples of groups doing that, they were struggling to do so. And then you saw a little sentence being added to the VMO where it said that communities might take on duties that local governments were now responsible for within the VMO. So that's sort of social domain. and that opened a whole new practice. So even though it didn't make it obligatory for local authorities to do so, just the fact that it was said in that legislation now that they could, it opened a whole new prospect. And then when that showed sort of that new practice, actually we saw, well, it depends on sort of the goodwill of a local authority. So maybe, because this is now happening, should we not indeed codify it and make sure that this is available to all communities, regardless of which local authority they live in? We're not there yet, but I guess you sort of see that iterative process where the society moves a little bit, and then maybe you codify a little bit to encourage further uptake, and then so on.
Thank you, great. Rene, do you like to respond? I'm sorry.
Yeah, I try to understand because I think what Danielle says is very interesting. What is first, societal change or law? And actually, I think in Flanders we see both tendencies. Let me start off a little bit optimist in the sense that especially in the second half of the 1990s, we saw, let's call it front runners in NFM that were really able of setting new planning law, new environmental law, and really bringing a new dive in more sustainable handling thinking in Flanders. They really set out a new planning culture, a new way of doing things, involving much more society than before. Before, destination plans in Flanders, they were made at the tables of politicians in cabinets, and if it wasn't a day during official meetings, it was during the night, taking the plans out of the stands and coloring in themselves illegally. So here we saw it, but we also see this tendency of law just setting the status quo, as you say. I think the most the most particular way of illustrating this is the conception in Flanders of what we called historical grown companies. So this is companies, they grow a little bit, they are somewhere, they grow a little bit without any permits, and then the government said, okay, they are historically grown, and now we go to legalize them. So law is following here the status quo, but to end a little bit optimistic, my belief is there is a very interesting thing going on with European legislation becoming much more stricter, but also the way that we can measure thresholds, how we can measure and monitor development. And this is being taken on board in courts. And I think this is very similar in the Netherlands and in Flanders, where you see that we are, with what we want to do with society, we are against these boundaries. And so this creates a necessity of new law being made, or another way of other types of law that being made. And maybe the front runners and the early adopters at this moment, they are in Europe, but most probably not in Flanders. But this is a personal opinion because this is recorded. Eh?
Yes, you better be a little bit. You cannot say the things too loudly. I agree. Thank you, Rene. Rogier, can you respond to Danielle or to?
Yeah, well,
Kristel?
I think law and also environmental law is in its nature always reactive. So, and if you look at our new but already old Environmental and Planning Act, which is in preparation for over 10 years now, it's already looking a bit outdated, because if you look at it, 10 years ago, we wanted to have a lot of discretion at the local governments, and that was really a big trend, and every municipality should do what it wanted. And well, I'm a bit exaggerating, but and now we are seeing, no, the central government should take more control and should do more and should be more clear about how the Netherlands will look like in 10 years. And if you look at our new Environmental and Planning Act, it's already outdated because it does not provide in control from the central government, because we didn't want that 10 years ago. So that's the big problem with law. It's always reactive, but I don't think it's a huge problem that law is reactive and always a bit late, because it gives us time to reflect on what we want and how we can change that law if we want in the future.
Great. Yeah, great. Thank you. Sorry, I was looking for the unmute button. There are questions coming in, and there are actually also quite some questions about the programmatic approach. We are in an international audience, so I think people are quite interested in it. There are questions from Ebru, but also from Thomas Magiels, and they are, I think, asking related questions. Given the constraints of the programmatic program for facilitating adaptive management, how do you perceive the relationship between flexibility and legislation for spatial planning in general? Can we institutionalize adaptive planning, and how? Can we answer calls of planning scholars who advocate for more adaptive planning to cope with uncertainty? So this is this tension, of course, between flexibility and legality. Yeah.
Well, I think you can, but you have to be really careful with the scale of your programmatic approach. Because if you want to have a more flexible system, you have to be aware of what I'm going to do, what I'm going to monitor, and how I'm going to adjust it without causing irreversible harm to the environment. And here you see, if you want to implement a programmatic approach combined with a precautionary principle or precautionary structures, you have to be really careful. But if you put in you can use a programmatic approach on a much smaller scale, and if you are able to monitor the effects of your decision, and if you are able to see the cause and effect relationship between your decision and the effects, and that's quite important. If you know you can see those effects and that relationship is clear, then you can use a programmatic approach. It can be a very useful instrument, but you have to be careful with it.
Yeah, and as far as I understood, that the capacity of municipalities to monitor these programs is not always there.
No, but sometimes it's even with air quality. Now, a lot of civilians have a lot of possibilities to monitor their own air quality in their own area. So sometimes it's even better when municipalities monitor. It gives a lot of feedback and a lot of information. So sometimes it is a solution, but not always.
That's great. I want to ask Kristel the question also about the flexibility within the Omgevingswet, because in your presentation you also started, well, there was some hope for the Omgevingswet that civil society would get more influence and could also easier start projects. And do you think that the current flexibility within the Omgevingswet helps civil society or doesn't help civil society?
I mean, I think in practice not. I think if you look at some of the pictures that I showed, and that's maybe more to do with sort of informal power and the lack of formal power, the combination of those two. So basically they're market parties with the means and the knowledge and the know-how and access to decision makers that basically have more freedom within sort of the omgevingswet, whereas in theory community groups could make use of that, but they don't have those means and they don't have access or the knowledge. And then because there's less sort of perhaps a less formal role for local authorities to really steer or take control of that process, you know, they put it more in the hands of potential commercial property developers or project developers. I think actually it's becoming less, so that's a real concern.
Yeah, thank you. Very interesting. And Rene, there is a question from Gumet. What were the criteria in choosing a sample of different international examples to look at? And I think the audience was also very interesting in if you have more interesting countries that really stood out next to Ireland.
This is work being done at a department, not at a research institute. So I think it was very. So I think we had a very pragmatic approach. One, we needed to be able to read documents that we could find on the internet. So there should be documentation. And we always looked just for having this cross-cutting element of environmental and spatial policies bind together. And yeah, we just had a very intensive web search. Yeah. So nothing.
And were there other countries that stood out as an example for what you tried to achieve in Belgium?
Yeah, actually, very funny. We had it was a local plan from Kokstad in South Africa, and we were very impressed of their way of formulating very integrated community development. It was very much community development based, very integral. So it was really like town planning, but not only the space, not only, but taking all the aspects of this. Yeah, it's a rural town of development, binding it together in one plan. All the money going there, and having one conversation with the community in how to allocate money and selecting preferable projects to be realized. I found it was quite impressive, and you don't expect it somewhere in the countryside of South Africa, but it was. I was impressed.
Great. I think we will all look up this example. It's very interesting. A question to Kristel from Tanya. Can you elaborate on the difference between implementing community initiatives between the Netherlands and the UK? To what extent differences in planning law systems empower or disempower these initiatives?
Yeah, so I think there are two things. There's I guess a bit more of a supportive environment. There's also a slightly different tradition, I guess, so that makes a difference. But what I was mentioning around neighborhood planning, but I guess also the community right to bid. For example, there's funding to buy support. So, or you might want to, if you want to do a community right to bid, you want to take over a community asset, you could get £10,000 to buy in support, for example. So that's a very sort of basic way, but progressive way of getting that informal power sorted. If you look at community right to bid, I'm not entirely sure if the legal framework did that much in practice. It was more, I guess, to promote that it was there. I could go into that in a bit more detail, perhaps another time. I'd be happy to talk about that. Neighborhood planning was a really specific legal framework, which has been tremendously helpful. The idea that you can actually just make a local plan, and that has to be put to referendum locally. And if the referendum has a positive outcome, then that has become the new plan. And it just has to meet obviously it has to meet certain requirements, and it doesn't have to go against national planning law. But I think that is a tremendously strong, and I've really been amazed by the take up. So often you would see that the quality of these processes is so high that both the turnout to these referenda was really high. So sometimes 70, 80, sometimes even 90%. So if you compare that to turnout with sort of local elections, that's really, really high. And also almost, I think, in my time, I think 95% of these neighborhood plans that were put out to referendum had a positive outcome. So people actually, and often at very high rates as well. And the fact that we don't have that in the Netherlands, something that you can actually fall back on that rate, I think makes a huge difference.
Yeah, great. I'm getting the feeling that together with the speakers and the audience, we could maybe write a very community-driven, flexible, yet not disastrous planning system. Rogier, there's a question from Tobias. The precautionary principle shuttled the Dutch programmatic approach on nitrogen, but are there more Dutch policy approaches that are under threat because of non-compliance with the precautionary principle?
Quite a difficult question. It requires an overview of all Dutch programs. I don't think so. I think it's mainly a nature conservation problem, because if you look at the European precautionary principle, it is implemented in the Habitats Directive and in the Birds Directive, and maybe in the Environmental Impact Assessment Directive. So you can see the precautionary principle in those fields of law, but in other fields it's not that significant yet. I think it will change, because the precautionary principle is on its rise, and it is getting embedded in more and more regulation. So it might be a problem in the future if you want to combine the precautionary principle with a programmatic approach. But until so far, I think it's mainly a problem if you work with the Habitats Directive. So, but that is also where a lot of government want a programmatic approach, because nitrogen is, I think, one of our biggest problems at the moment. And that's a problem related to the Habitats Directive. So here you have our problem, the tension.
And maybe may I ask a question, Rogier? Because I think within 1 or 2 years, the new water directive will be put in place.
Yeah.
Also setting new thresholds for water quality. And here in Flanders, we will expect this will have quite some impact on possibilities, in particular in relation to traffic and farming. How is this being perceived and expected in the Netherlands?
Well, I think that's exactly the same, and we also have a lot of problems with our with the values you have to reach within the framework of the Water Directive, and but in that field you hear that some lawyers also want a programmatic approach embedded within the Water Directive, so that could be a problem also.
Yeah,
because there you also see the precautionary principle actually in the directive itself.
Yeah. And Rene, while listening to your presentation, I had a feeling that sometimes you think that the Dutch omgevingswet tries to do too much. Is that true, or?
No, I think they wanted to integrate too many laws. And they were so much focused on this idea of simplification, just having less text, that the idea of what is the key aim, the core objective underpinning the omgevingswet, it has been a little bit set aside, I think. And you see there is some easy measures, gemaksoplossingen, being taken, and then you get this list. Physical living environment is, and you have this, and might comprehend amongst others, and a list of 26 themes, and you are thinking, what is this law actually about? But we see precisely the same thing happening here in Flanders, having all these different degrees being approved on integrated permit delivery, etc., etc. But here we have in well, what we hope, what you see is that the development of content, the development of really substantive concepts, which is policy, I believe, and should be integrated, and the underlying base also for legislation. We try to develop it here. Because we know that something like an omgevingswet will once be on our table as well, but we are quite puzzled. It's really not an easy question,
Yeah. No, but also based on the presentation, of course, of Kristel and Rogier, the ambition of the omgevingswet sometimes backfired. I think this also has to do with like the aim of simplification. Well, the content is of course very complex, so you want to give these communities more space to take initiative and to develop things, but you also have to control it. And yeah, same with the programmatic approach. You want this flexibility, but how are you going to monitor it? So yeah, I have sometimes the feeling that the omgevingswet wants to do too much. Also, and that's not touched upon today yet, but the digital system that's being introduced, that's another layer of complexity. And yeah, well, I think it's the 4th or the 5th time that they postponed. Fifth, yeah. The 5th time that. And
there will be probably a 6th time.
Yes, do you believe?
Yeah.
I'm so done with it. Just get over with it.
It doesn't function. It doesn't function. No.
Yeah. Yeah. Okay. Thank you all for being here, and we're going to wrap up. But I want to hear from the speakers. What is the most interesting or new thing or novel thing they've heard today from the discussion from each other? Just in one sentence to summarize a little bit our lessons from today. I will start with Rogier.
Well, the most interesting things I've heard is learning about participation in the UK and how they're probably doing it better than us, and learning about how the Belgians are looking at us. But I really hope they will be continuing their critical view of us, because it's not all good from the Netherlands, I think.
Thank you. Kristel.
Yeah, so as I mentioned, for us, it's always a joy if we get to have the chance to understand a bit better on how it actually works in practice from, a planner or legal expert. So for me, I think understanding a little bit about what it means to work with a programmatic approach and how that maybe affects sort of practice and some of the discussions also that community groups might have with their local authority is something that will be going around in my head for a little bit longer. So thanks for that.
Great, thank you. Rene.
I'm afraid this is one of those webinars that I'm leaving even more puzzled than I entered them. And I'm really now puzzled on how to combine this idea of these technical thresholds on the one hand, and on the other hand, this civil society involvement. I think this is a very tough question that hard nut to crack.
Yeah, great, thank you. And then our discussion, Danielle.
Yep, trying to unmute. I think a lot of things on content that I'll remember, but maybe the thing to note on right now is what a great conversation comes when people coming from very different expertise and very different background come together, tell about their own expertise, and then are able to connect and build together forward. So I think the vibrant discussion is something I'm going to be taking away. Leading me to what I also always like to be the optimist view on how we can move forward together.
Great, thank you. Then before I let everybody go, I want to make a little bit of advertisement for our next webinar series. On the 25th of February, we have a webinar series about law and policy in the European directives. As was mentioned during the discussion already, European directives sometimes unclear whether it's law, whether it's policy. We will discuss that with Pauline Westerman, a philosopher from Groningen University, Martijn Groenleer and Saskia Lafrijzen, who are professors at Tilburg University, and our own Tobias Arnoldersen. And on the 10th of March, we have a webinar series about issues in urban regeneration projects with Tuna Tessan-Kok, Joanna Kosiak, Robert Rocco, and Sense Turk. Looking forward to see everybody. Thank you for all the input and the lively debate also in the chat. Thank you for the audience. It was really great to hear your questions and your engagement in the discussion. And of course, a special thanks to Ebru and Gumerts, who did so much of the organizing work. I will stop the recording and the session. And for the speakers, we will send you a Zoom link to have a little chat afterwards. Thank you so much.